our class. Okay. Today we'll talk about one very simple topic in Evidence Act that is called opinion evidence. Okay, first and foremost, again, my disclaimers. I'm just a very junior person in the law, and this class is free of charge and it does not aim to cover all area of law. And of course, I cannot guarantee you the accuracy and also the quality of this class. And I would love to hear from you after the class in regards to the improvement that I can make to make this class better in future. Okay. Opinion of the evidence. What is that actually? So by right, the court system itself is a place where justice is served, isn't it? So most of the time, we can only seek to admit facts. That is the information perceived by our five sense. That means our eyes, our ears, and then our tongue, etc. The five sense that human being can perceive, that is categorized as fact, because an eyewitness can say he or she see the murder happen, for example, but he cannot give something like opinion. I think she killed his wife. So this is what you think. This is so-called opinion evidence. You must distinguish whether the evidence itself is a factual evidence or it is derived from opinion merely. Very important, okay. uh okay, we go to next. So facts are everything that is capable perceived by five human sense. Again, that one I already told you. Whatever you see, whatever you feel by touching, whatever you smell it, whatever you hear it, or you feel it by tongue, these are all five sense. These are categorized as fact, and those facts itself must be given as first-hand information. This is another rule, what we call as hearsay. You cannot pass the facts around or transmit the information to party or second party, etc. Cannot. The witness or the evidence that you put forward into the court should be a direct fact. Very important, okay? Facts. So evidence is what? Evidence is that body of testimony a party put forward to support their case. This is called evidence. Okay? This is evidence, keterangan, okay? And evidence can only become proof, bukti in bahasa Malaysia, when the judge, after consider the totality of this evidence, as well as all the factual or whatever circumstances of this case, either choose to believe those facts to exist or consider the probability of these facts. Because at the end of the day, you must always understand that it is a dealing between you and the God. Most of the time, especially criminal matters or even civil matters, only God knows what exactly happened. So, in terms of evaluation or judicial appreciation of a certain piece of evidence, we will render it to a certain degree of probability. That is, in criminal sense, we use beyond reasonable doubt, whereby in civil case, on balance of probability. That means more than 50%, then you will win the case in civil lah. Okay. So this is how the flow of your study should be. So facts, you should understand what is the definition, and then subsequently you must know what it is to be an evidence that is at the stage adducing by the party, and then the evidence only become proof, bukti, after being assessed by the judge. Okay, so the court's decision must be the end product of judicial reasoning based on proven facts and legitimacy of the inference derived from those facts. So that means to say, the court decision at the end of the day is either conviction or acquittal in criminal court. There's no 50-50, In civil proceeding, only plaintiff or the defendant can win the case. You get me? So you must tilt your what we call your errors to the right or left. There's nothing in between. Okay. This one also you must formulate your answer. If you are siding, for example, prosecution, all your answers should be leaning towards the side of prosecution. You cannot just like in between. Okay. And witness are generally not allowed to inform the court what kind of inference derived from the particular facts perceived by them, but they must confine their statements to an account of such fact. Okay, when I see somebody, for example, A kill B, what I see from this incident, what I saw from this incident probably is A was stabbing the heart of B. I must state what I say to the court. I cannot say something that, oh, it's very dark. I hear some noise. Okay. And then I saw the shadow looks like A running away from the C. And I think because B already found that at that particular scene. So I think I put something like that in my witness box in the court. I think A must have killed B. This is wrong, subject to the objection. Okay. So if the witness, having said so, interprets the facts which he perceived his offering his opinion. This is no longer something that you can perceive from your human five senses. This will be amounted to opinion. And bear that in mind, the court will not need opinion of somebody to form their ultimate or final judgment. Okay, I repeat myself. The court will not often require the assistance of anybody's opinion to form their final judgment. Okay, please, this one very important. So whatever I think, okay, this is something I or make out a report based on my assessment of the pre-existing facts. Those will be categorized as opinion evidence. Okay. And what are the relevant laws that governing the so-called relevancy? Okay, relevancy of opinion evidence would be from your section 45 until section 51. Do not make a mistake. Opinion of third party, okay, third person when relevant, it is from 45 to 51. It's not just one single section itself, or section 45. That cover all the, what we call the opinion evidence. But rather, I want you to look into the detail, at least you know the heading. So section 45 talk about the opinions of expert. Okay, expert. Section 46 talk about facts bearing open opinions of experts. And section 47 talk about very particular opinion as to handwriting when relevant. Okay, this is particularly important in some sort of forgery case. And section 48 opinion as to the existence of right or custom when relevant. Okay, section 49, opinion as to usage, tenants, etc. when relevant. And section 50 is opinion on relationship when relevant. And section 51 That one is also this one, 45 and 51 are the most important one lah. Okay. The ground of opinion when relevant. Okay, because at the end of the day, when you want to give opinion, you must support yourself with certain basis, whether you get this inference from your background expertise or experience, supported with what? So it will help to the court to substantiate your claim, you know. Okay. And in furtherance to this Evidence Act, you must also cross-refer when the question required you to do so to Section 399 of your CPC, whereby in this particular section, the report, if it is given by prosecution, by those government officers, for example, the chemists from Jabatan Kimia Malaysia, sometimes the attendance of the said chemist that write the report will be dispensed with. He or she, the chemist, will not be compelled to come to court to give evidence pursuant to Section 39, 399 of CPC. This is also a procedural rule for hearsay exception. Okay, very important, eh? And you have actually two types of this what we call, why is become okay, two types of opinion evidence. One is expert's opinion. The second one, though the person is not a particular academically qualified, for example, a medical doctor in that particular field, a non-expert also can be allowed to give opinion in the court, provided they got some background relevant experience. Okay, so those are two categories. So expert opinions usually are those who are statutorily gazetted. For example, the person uh, RMP, registered medical practitioner under Medical Act. For example, the what we call the architect that registered under the MIA, for example. So those are actually the person that possess with a certain level of technical or scientific knowledge. They their role is very simple. They are in the court with one objective, that is to help the judge who is less exposed to that particular field. Take, for example, medical field itself. The court or the judge has no prior knowledge in pertaining to medical knowledge. Therefore, they will require a medical expert to tell you what actually happened in the hospital, whether it falls short of the standard of care or not. Or sometimes they will need a forensic pathologist to tell them what is the exact cause of death in particular murder case, for example. So the expert's role is merely to assist the court to arrive at a proper conclusion at the end of the case. So bear that in mind, the expert opinion is there to help the court. Okay. Mm.
Okay.
And you must cross-refer to Section 45. Okay, Section 45, when you talk about opinion of experts, because the proviso itself specifically provide for opinions of expert, as you can see from the heading. Okay, please be familiarized with what it is. So Section 45, if you have the statute with you, okay, you can read from Section 45, Sub-Rule 1. It sounds like this. When the court has to form an opinion, open a point of number one, foreign law. Okay, this is the first point, foreign law. Second point, science or art. Third point. Okay, science can, art also can. Okay. Or as to the identity or genuineness of handwriting or fingerprint. So four fourth point is handwriting. The fifth point is finger impression, fingerprint lah. Okay. The opinion open that point of person specially skilled in that foreign law. Again, the law repeat itself. Number one is foreign law. Number two, science. Number three, art. Number four, in question as to identity or genuineness of handwriting. That is point number four already. Or fingerprint are relevant facts. So the experts can only come into those five category. Okay, I repeat myself. Foreign law, science, art, handwriting, or fingerprint. Okay, that's it. Okay. And such persons are actually called expert. This is the statutory definition for experts. Other than that, those person that is out of these five particular areas, they cannot be called as expert opinions. Okay, this is statutory provision. Okay. So science, for example, will be your this one secondary school basic science, the foundational science that will be biology, chemistry, physics, medicine, etc. Okay, but it also cover like for example the recent KLIA shooting case, isn't it? Some sort of expert they will come to give the GSR, the gunshot residual evidence in the court. Those people are expert witness lah. Okay. Art will be in this category referring to painting, music, literature, drama, etc. Okay. And these are the illustration that I think you should be familiarized with your for the sake of this CLP per se. The question is whether the death of A was caused by poison. The opinion of experts as to the symptoms produced by the poison by which A is supposed to die are relevant. Okay, so that means to say probably the one expert will come to give opinion pertaining to some sort of poison, for example, warfarin, arsenic, the hydrogen peroxide, which are the very popular poison for people to murder somebody. Okay. So the symptoms displayed by that particular victim will be relevant, if the so-called the experts give opinion that is almost tally to the symptoms prior to the death of that particular victim. Okay. And this is another illustration B. Okay. The question is whether A, at the time of doing a certain act, was by reason of unsoundness of mind, incapable of knowing the nature of the act, or that he was doing was what was either wrong or contrary to law. The opinion of experts open the question whether symptoms exhibited by A commonly show unsoundness of mind and whether such unsoundness of mind usually renders person incapable of knowing the nature of the acts which they do or of knowing what they do is either wrong or contrary to law are relevant. So here what this illustration B is trying to say is if that particular person, usually the accused lah, is raising the defense of insanity, is crazy at the time of commission of a certain crime. Okay, so how to support the validity of this sort of defense of insanity? Definitely, the defense counsel will need to engage a so-called psychiatrist, isn't it? To prove that my client, definitely my client, yeah, the accused, okay, will have some sort of schizophrenia, depression or delusional disorder at the material time when the crime was committed by him. So the expert here, the evidence itself could be admitted, it is relevant, because it formed part of the so-called defense. Okay. And if you look at this case of apa nama Chandra Sekaran against PT, the expression science or art is elastic enough to be given a liberal interpretation. Okay, and the fact that the section does not specify particular fields of knowledge does not mean they are not included. That means to say, even though section 45 only categorize into science, foreign law, science, art, the what we call the handwriting and fingerprint, but that does not mean it is only limited to this scope. So the court actually by this case stretched the interpretation of this section 45, okay, so a lot of things can be included because strictly speaking medicine itself is not science, those are two different words, isn't it? But at the same time, if you stretch science, it could involve a lot of things. It could also involve astrology. It could involve like biophysics, chemistry, as we have discussed. But of course, it could involve a lot of um more other things. Even sometimes, if you want to stretch further, social science it is also one science here. Okay. So this is what this case trying to say. Okay. And section 46 further provide that, okay, even though section 5 said that only facts in issue or relevant facts could be admitted when we have a trial, isn't so? But section 46 open the room for opinion evidence in furtherance. If let's say, for example, the facts not otherwise relevant are relevant. That means the fact itself are actually not relevant at all. But if they are here to support or to rebut the opinion of experts, such facts would be relevant. You get what I'm saying or not? Section 45 is providing for the room of opinion of experts to go in. Section 46 here provide more rooms for new facts to come in to support the opinions itself or to rebut the opinion. Okay, so these are open for more evidence to go in. Okay, I hope you can understand. Okay. So the illustration here, okay, we come back to the poison issue, because this is the classical example given by the statute. Okay, the question is whether A was poisoned by a certain poison. Okay, the fact that other person were poisoned by that poison exhibit certain symptoms which experts affirm or deny to be symptoms of that poison are relevant. Because at the end of the day, you just imagine A trying to murder B by a certain type of poison, arsenic, for example. Okay, by right, the symptoms is like you have shortness of breath, palpitation of heart, and then sweating, profuse sweating, and etc. And then you collapse and die. So these are the cardinal symptoms. What if other people also display similar symptoms by statistic, showing same example, same sets of symptoms, if they are to die with arsenic poisoning? So these are coming in, even though the death of that particular person, by right, if you read strictly section 5 of your Evidence Act, it has no bearing at all with this particular case. You get me? So, but due to this opinion evidence, it opens room for other person punya symptoms to come in to support or to rebut this particular expert opinion. Okay. And talking about this opinion evidence, it is very important because this opinion thing is an inference, from what you think. I repeat myself, opinion is an inference from the facts. That is in layman to say what you think about a certain thing lah. So the person that give opinion evidence should himself or herself be present in the court to give oral evidence. So this is in reference to your section 60. If you want to read closely, that will be section 60, sub rule 1 and sub rule D. Sub rule 1, sub rule D lah. Okay, so opinion evidence mode of proof is by direct oral evidence. Because why you need oral evidence? Every time a witness go to give oral evidence in the court, he or she will be subjected to three stages. That is to say, examination in chief, cross-examination, and subsequently there will be a re-examination. So all the facts that the court or the parties are not satisfied with each other can be verified through this process itself. Okay, so the genuineness or the weight of this particular expert, so because opinion ma, what you think ma, okay, so can be more clarified during this process. Okay, so section 60 important and okay. So Section 60 further said that the opinion of experts expressed in any treaties, lah, okay? The usually treaties is the perjanjian between the countries, lah, commonly offer for sale and the grounds on which such opinions are held may be proved by the production of the treaties if the order is dead or cannot be found. Okay, so except there are certain cell treaties, okay, whereby the order is that cannot be found, then the so-called um, oral evidence should be dispensed with, okay, should be dispensed with. But most of the time, they will be required to attend court to give evidence. And some more, I have told you, Section 399 CPC, provided you have to remember Section 399 can only use by prosecution. I repeat myself, Section 399 can only use by prosecution to tender expert or so-called this evidence in court without the need to call what we call their so-called government officers, especially in the case that often related to our practice will be chemist report. They will not require to call the chemist all the way from, for example, Petaling Jaya, the HQ there, to attend the court session in Mua, for example. Okay, but subject to those the criteria, okay, if their report is served on the accused person at least 10 days before the trial. But in practice, usually we go by the merit lah. There's a very less element of surprise attack here. So usually the accused person will be given the so-called the expert report about 10 days before the trial. And if the accused person said that, okay, I think I need to cross-examine the expert. Then, 3 days before the trial, the accused person must give notice to prosecution, the DPP lah, that okay, I want this expert, I want this chemist to come to the court. So this is what Section 399 tells you about, Okay, this one also very important. Okay, and okay, but having said so, the law itself is subjected, of course, lah. Lawyers, kan, we are good at finding whatever alternate alternative or so-called loopholes, lah. Okay, it is, however, open to prosecution not to serve the report at all. You get me? Okay, instead of serving you the report and then dispense the need to call the witness, isn't it? Pursuant to Section 399. Now, what I do is I call the witness as my saksi without giving you the report. So I will still give the other party surprise. So like that, huh? Okay. An accused person are not obliged under any laws to give advance notice of their intention to call any expert witness in their defense. Section 399 only applicable to prosecution side. Okay, I repeat myself at least three times already. So section 399 does not apply to accused. So accused person, that means to say, do not need to tender any reports. So when they are being called to defense, anytime lah, they can call expert to plead the so-called defense of insanity lah. Okay? So this is what the so-called a little bit the playground for the loopholes. Okay. And this is one example you can see. This is a chemist report. So usually prosecution will give you during section 51A CPC stage. That means to say they got whatever documents that will give play a nice and fair game lah. Okay, they'll give to you and what we call they will give you whatever the reports, what is the analysis of the chemistry test, and what is the weight and also the identity of the drug. Okay. So usually the person will need to identify themselves, okay, who are them, which unit they work for, okay, what kind of evidence they have examined or analyzed, and what kind of the results given. Okay, if usually the point to challenge, I mean the merit to challenge this sort of report, not much help lah, not much help in drug case lah. Because all we know is this sort of report are generated by the machine, okay? So it's not by so-called human opinion. That's why you have another case of Hu Hee Chiang here, say that sometimes observation of the weight, the berat dengan jenis dada sahaja merupakan satu observation that you see, That means it's fall under facts. You see with your eyes. Therefore, it is not even an opinion. So, it will be a challenge lah if you wanted to challenge this chemist report is forged, and then instead of the drugs, it is some sort of you know pong pong gandom and all that. Very difficult lah. Okay. Mm. And civil per se, if let's say for example, if the question required you to go a little bit extended, you may also wanted to discuss Order 40A because like I say, usually the court has limited time and resource. We cannot be arguing about what you think, So opinion evidence will be subjected to procedural rules. In civil case per se, you must follow strictly Order 40A, okay? About the requirement, how to call expert, to give affidavit and etc. This is very important, okay? To make yourself clear. Otherwise, you just call here and there this expert to come and testify this, the signature is forged. All that cannot be valid, You're wasting the court time in. So, Order 40A, if you are discussing some civil question, if it is necessary, then you may want to stress your question, your answer a little bit to discuss briefly on Order 40A, your rules of court, Okay. So these are the example that I can provide to you uh, on how this uh, the what we call the pakar punya pendapat lah, how we want to admit. First is by way of affidavit, and then subsequently we will tender the report, okay, alongside with this particular exhibit. Okay, so affidavit must be made. It's a sworn statement before the commissioner for oath about the so-called the genuineness of the report tenders lah. Okay, the expert must sign and tender this affidavit plus the report So this is what we call the format lah of the report. First and foremost, you must talk about who asked you to prepare. In civil, this one is civil one, okay? Who asked you to prepare the report and who are you? What is your background, qualification, and experience? What is the brief fact, apa fakta case ini? For example, medical negligence, what happens? The patients die in the hospital or what? What is the description of this incident? And your expert opinion based on what question that, of course, the person that engaged you want you to answer, want you to assist the court to seek for clarification. And subsequently, you may need to attach with your authority. What is your reference? What is the basis that you form such conclusion here? Okay, so this is the format lah, the format. Okay, so something like that. The qualification and experience will be stated. Okay, this is the geriatric psychiatrist apparently lah. So he'll give a lengthy discussion about his qualification because this has something to do with the weight, probative value of this evidence. Okay, and then subsequently, what is the opinion? Okay, so you have to seek what the question to answer to the court. Number one here, I highlight to you is to provide an independent written expert opinion on what procedure or diagnostical methods must be carried out in order to determine the current mental capacity of a patient, in particular to determine whether patient is capable of managing himself and his affairs. So this is the one that we as a lawyer provided, because I think this question is having some bearing on the case itself. We want to challenge the testamentary capacity, for example. So you engage an expert to give a lengthy medical view lah. Okay, and subsequently reference, and then you must sign. You must make one declaration that this what we call this report are true, and then the opinion I express are correct, okay, and I have an overriding duty to the court, okay, etc. These are the declaration that must be made by the expert to prevent abuse or exploitation of expert to influence the decision of the court. Okay, very important, And subsequently, you can see here from Sheikh Abu Bakar against PT, expert opinion is only admissible to furnish the court with scientific information, which is likely to be outside the experience and knowledge of a judge. Like I've told you earlier, opinion evidence is not often, it's not, tidak selalu, okay, not often being admitted by the court. But rather, if the judge thinks this is a niche area of expertise, then they will allow. Okay, this is what it is trying to said by this Sheikh Abu Bakar case lah. Okay, and during the course of his testimony, the expert may have to refer to documentary and real evidence to support and illustrate his testimony. So sometimes expert will need to rely on treaties and other extrinsic materials to support his opinion. Like the one that I've told you earlier, section 46, you can rely on other so-called initially irrelevant facts to this matter, but subsequently you want to give opinion, yes, other people punya poison symptoms, you can seek to admit to convince the judge. And section 51 further said that whenever the opinion of any living person is relevant, the grounds on which his opinion is based are also relevant. Why you say so? Why the experts say so? On what basis? Okay, so an expert, the illustration given, an expert may give an account of experiments performed by him for the purpose of forming his opinion. He probably can tender his research study to show that, take for example, stem cell therapy is helpful for the recovery of a stroke patient. Okay, so these are the thing. Okay, so how competent must the expert be? Okay, number one, the expert could be professionally qualified or what we call as gazetted expert lah. The statute, the medical act, for example, recognize the registration of this particular expert, Okay. Or second thing is experience lah. He or she must have experience relate specifically to the matters in issue. Okay. So this is pursuant to your Junaidi bin Abdullah case. Okay. So Pacific Pin Consolidated Corporation against Hun Wee Tiam said that, okay, the summary of how to make sure that we deal with opinion evidence or expert opinion nicely. The first requirement here is that the emission of expert evidence on any particular area of this is that a relevant field of expertise should exist in the sense that there is an organized branch of knowledge in that particular discipline. Okay, first requirement, first thing first lah. Handwriting expert, there is a recognized field. You cannot suddenly create your version, you cannot say clantologist is something that exists, even though it is not. You cannot say that, oh, evidentologist, because you study evidence, so you say that I'm the expert in evidence law. I say that I am an evidentologist. But this field itself is not even exist. How do you want to call the expert? Cannot. So it must be a recognized area lah, in short. Secondly, okay, only a person who has acquired specialized knowledge by a study of that discipline and thereby has qualified himself can be regarded as expert in that specialized area. Like, for example, in medicine, we have a lot of specialty and subspecialty. For example, subspecialty would be pediatric, neurosurgery, pediatric surgery, or we have a gastroenterologist, all these weird term lah. Okay, you must have gone through certain period of years to study under, for example, University Malaya, USM. Okay, then only you can call yourself as the expert specialized in this particular area. Okay, and thirdly, this one is the most crucial. The facts open, which his opinion is based, must be proved by the party calling him by admissible evidence. So the facts, all the burden will lies on the party that call that particular so-called expert. For example, if I want to say this document is forged, I have to produce a lot of sample of the signatures and then send to chemist department to analyze. So all these I have to substantiate with my primary facts. You cannot simply call a expert opinion to say this signature is forged, but whereas the primary fact itself, let's say it is false, but how does it help with your case? Eventually, you call expert, yes, you get the report say that the signature is forged, but it is useless to your case. For example, you are dealing with for a matrimonial proceeding. You want to divorce, you want to find the ground for divorce, for example, adultery, unreasonable behavior, etc. But this forgery thing is just about the transaction of the house. It has no bearing with the matrimonial proceeding. So it is useless. So you cannot do that. Okay, wasting court time. So in PP against Lin Lian Chen here, okay, it's a long, it's a long description, but I hope you can read it when you have free time. So it is said that the chemist, when he's giving a so-called expert opinion, he only highlight his qualification and a little bit of experience. I have been in the chemistry department for 13 years. I have a Bachelor of Science degree in measuring in chemistry, and I have a diploma in blood serology. Okay, so that's all. So apart from that particular fact, no other evidence was led at all to substantiate that the witness has necessary experience in the analysis of dangerous drugs, lah. Particularly in this Lin Lin Chen case, is heroin. So the court throw out, the court said that this is not expert. So you get me? Because the prosecution, the one that call the person, by right, you should highlight what is the qualification and experience of your witness, your expert witness. So you have the burden to satisfy to that requirement under your section 45. Okay. And Ku Hai Chiang here is another important case for you to distinguish factual evidence and opinion evidence. Like I have told you before, if it is concerning to drugs, usually the norm of the criminal practice, as what I've been exposed to as to now, we don't usually challenge the chemist report's validity because under this case, Hu Hai Chiang case, it is said that the identity and the weight of the drugs constitutes evidence of fact. It is not an opinion because you must roughly figure out what kind of process that led to the findings. Okay, it's just by putting the powder, the powders, and then analyzed by the machine. Then you have one report, berapa berat, per jenis dada. So this is not even an opinion, isn't it? It is observation from whatever print out from that analysis machine. So this is a fact rather than an opinion. Okay. And PP against Muhammad bin Sulaiman said that an officer who has no special qualification in ballistics, that means gunshot, except experience, was giving only factual evidence. So strict applications, if you do not have, normally nowadays, experts will be backed by their beautiful CV, their academic qualification, as well as their experience. Usually, they are the so-called key opinion leaders of that particular field. Okay. Uh, so these are all these old cases. And when you have conflicting evidence, take for example, um, medical negligence case. The expert of the plaintiff was said the doctor performed below the par, and the expert called by the defendant will definitely cite their what we call their defendant, isn't it? Otherwise, they will not be called. That is logic sense. Okay, so what if you have those difference? How that the court can evaluate? Okay, in dealing with conflicting evidence. So in case of PP against Ang Sun Huat here, it is necessary for the prosecution to produce additional expert evidence. For example, from the writings of another internationally accepted expert in the field. Okay, so this is how it do. When you have two more or less qualifications same, I mean experience also same, weakness expert weakness, but from different side, but seeing the contradicting to each other's opinion. So the court usually will invite the experts to sort out the issues. This is the first step lah. If the problem could not resort to a proper consensus, okay, the court will require prosecution to call somebody international maybe the number one in the world in this forgery field, in the handwriting field, to give their ultimate opinion. Okay. Huh. So the court in this Singapore finance against Lim Ka Ngam, the court can choose which expert they believe it. That is subject to their very own discretion. So this is how the courts approach when they have conflicting expert evidence. Okay. And non-expert expert opinion can be allowed under your section 47, which allows a non-expert to state his opinion on the handwriting on condition that he's acquainted lah, with the person's handwriting. Okay, this one very famous in Shimbaga Valley against Tan Chia Fu case. Okay, one JB High Court case is about forgery of one's transaction of a property. So whereby uh, our ladyship, this Maria Peter, she highlighted actually a lot of ways that you can seize the court to compare a person's handwriting. Not necessarily we must call a handwriting expert under section 45. You can actually ask the person to sign on a sheet of A4 paper, and then the court can compare themselves by looking like the similarity of the handwriting, or call the person, for example, the clerk that had been tagging with this person for five 5 years, 10 years, like that, very familiarized with this person handwriting. She can testify as non-expert opinion, etc. lah. Okay, there are various way there. Okay, and section 48, 49, and 50 that I have told you, but this one we hardly use lah. We hardly use in court. Okay, 45, 47, and 51. These are the most important section. Okay. So like I say, this is going to be a shorter lecture as compared to my previous one. So we will go to the discussion of the question. Okay, I will read you out. This is past year question. Bang is charged with causing Chabo, his girlfriend's death by reckless driving. While driving, Bang had a heated argument with Chabo and lost control of the car that resulted in the accident. Bang argues that at the time of the accident, he suffered from an underlying psychological and psychiatry defect, and the heated argument with Chabo affected his state of mind. So Dr. Ismail was called by the accused and gave evidence that the accused suffered from some infirmity of mind. Dr. Ismail testified that Ben was emotionally attached to his girlfriend, and the aggravation from the heated argument had affected his mind. The death of his girlfriend had now caused the downward spiral of depression in him, so much so that Dr. Ismail had to resort to electroconvulsive therapy in treating Ben's depression. So, first and foremost, please identify Dr. Ismail is who? Siapakah Dr. Ismail first? And then, what is your role here? You are judge. Okay? You Tuan Hakim lah, or Puan Hakim. Okay. And then you are required to make reference to Evidence Act and relevant case law. So read the question carefully. Okay. So you are first asked in relation to our topic of discussion, you are asked to consider Dr. Ismail evidence. Okay. 15 markah. Okay. So don't think that you get a you get a how to say this is jackpot. Wow, I get a opinion evidence. Happily you copy down the section 45, section 51, then you think you can score. Actually, in practice, it's not like that. The suggested answer is more or less like this. Okay, so this is a criminal case. I'm sure everybody can follow now. It's a PP against bank case here. So what is the charge involved? Okay, as previously I have read to you. Okay, we go to the previous slide. It is causing the girlfriend's death by reckless driving. Reckless driving. So evidence act itself is related to the primary theme. Uh, because any evidence must go through three stages. That is to say, relevancy, admissibility, as well as the weight of that particular evidence. So how do we determine the evidence itself is passing the first rule? It must be relevant to the charge itself. The charge here is section 41, Road Transport Act 1987. And you are the judge here. So make sure you chonteng here and there. You must highlight these three things first before you go into the answer. Okay. So what I will propose is the answer. Okay. This is to bring to your attention, section 41. You don't have to know in details, but at least you know the existence of this, apa nama, the offense. Okay. So in performing the duty as the presiding judge, when considering Dr. Ismail evidence, so reference is made to main charge first, section 41 RTA 1987, as well as you have to cover this one. Section 45, 51, as well as 60. 60 is mode of proof. Very important. Okay. So how do we go by this? Because whenever you must be clear by now, whenever you have a specific act, it's like um Sexual Offense Against Children Act, the SOCA 2017. Okay, when you have this corruption, the MSCCA, when you have money laundry, the AMLA 2001, all that, you must make specific reference to the act first, then you go to your procedural statute. So this is how the thing work. So you make first reference to your section 41. Okay, you roughly discuss, or section 41 provide that reckless driving. Okay, that means to drive the motor vehicle in a very reckless or the speed or manner which, considering the circumstances inclusive of the nature, condition, size of the road, amount of traffic, okay, which is dangerous to the public, then cause death of any person shall be guilty of an offense. So this is the main charge against bank. Roughly discuss a bit about that. So the discussion shall focus on actus rea and mens rea of this provision, because you want to see whether Dr. Ismail evidence is actually relevant or not to this charge. Otherwise, no need. Like I said, opinion evidence itself is not so welcome by the court, isn't it? We want to deal with the facts of the case rather than what you think. What you think is not important to me, because I already know. The judge already know. So uh, you can draw out a case, Mat Atan Ahmad against PP. So what is the actus rea? Res here? Actus rea is not being challenged. So you have to discuss briefly objective test and then causing inconvenience, annoyance to other road user. Okay, comparing to the reasonable road user. Okay, the important element here is mens rea. Mens rea refer to recklessness is some sort of mental state that the driver, in giving no thought to the possibility that being of having a risk amount to danger to public. That means he's not aware lah. He's not aware that he's driving in a manner that is causing harm to the public. So mental element is the one that challenged by the accused. Bear in mind. Okay, so such inference of recklessness may be rebutted by the explanation and evidence of the driver as to his or her state of mind, with regard which regards must be given to. Okay, so briefly, actus rea, mens rea. So you subsequently, because you are presiding judge, you must be well versed with the law, isn't it? So you must say so. Bank is raising the defense of insanity to challenge the mens rea element of the offense by adducing opinion evidence of Dr. Ismail as expert witness. So it show to the examiners that, wow, you know already. You talk about brief facts, and then I mean the main charge itself. Then subsequently you identify this is about the MR, the mens rea component. So, therefore, first and foremost, such evidence is relevant to the facts in issue, Section 5 Evidence Act, and therefore 100% admissible by this honorable court, Section 136. Okay. Next, the court shall discuss the statutory requirement of Dr. Ismail evidence. So you fall back to Section 45 and 51 of your Evidence Act. Don't be too quick without 15 marks question. It requires a lot of, how do I put forward to you? It requires some background knowledge, and also to show that you are qualified lawyer. So you have to submit in this manner. You cannot just quickly, or section 45 say that can can go in. Then you'll get very poor marks, you know. Oh, okay. So section 45, 51 to ascertain the infirmity of mind as pleaded by the defense, which falls into the category of science. Remember what I said just now? Only five categories the court can consider. So this is the area of science. The court will require the assistance of a third party, i.e. in this case, Dr. Ismail. Okay. So subsequently, you elaborate. Dr. Ismail is certainly an expert opinion witness rather than a factual witness, as he will need to clinically and medically diagnose Bang with his medical knowledge to reach the diagnosis of insanity. Okay, distinguished with Hu Hai Chang against PP. That is factual and also opinion. You already made up the mind, this is opinion already. Okay. Subsequently, you don't stop there. Subsequently, how do you give, because relevancy, admissibility, subsequently, weight, isn't it? So how do you take, because you are the judge, eventually I told you you can only decide this bank is guilty or not guilty. So you must consider the probative value of this evidence. So the court shall take into consideration of the important matters as follow. Number one, Dr. Ismail's qualification and experience. How good is he? How well known is he in this area of psychiatrist? Okay, but this one, you must put your stand. It only goes to the weight, but not admissibility. I think I made myself very clear. This evidence itself is 100% admissible. It goes only to the weight. You elaborate a little bit on the qualification and experience. You can use the case of PP Muhammad Sulaiman. Favorite case, this one. Okay. And number two is, what is the role of this evidence as to my decision now? You get me? So if they give evidence, I must follow you or not? I must follow your opinion. Can I form a judgment that deviates from your opinion? The answer is yes. The expert evidence is only used by the court for purpose of assisting. You see or not? Membantu mahkamah, but not to formulate the ultimate judgment. Put your stand, because eventually, because I want to use this case law, Wong Siu Chin here, is because that I want to convict this bank, you know. So you have to draft your answer accordingly. Otherwise, people will find error in your judgment, and then this is a ground of appeal. Good. Okay, so basis of Dr. Ismail. So relying to this section 51, Dr. Ismail must provide his reason, his ground of opinion. And then the court must evaluate these reasoning before coming to a finding. So this one we have discussed, Pacific Team Consolidated case. And finally, you must also consider how is the highest level of this Dr. Ismail. Is he an independent, newly appointed doctor? Or he is a pre-existing treating doctor of that bank? If he is the treating, attending physician of this bank, cannot be admitted as expert. Okay? He must be an independent uh, expert that did not treat bank before. Okay? You must get the ideas. Okay, so Dr. Isma, as an expert opinion, shall have an overriding duty. Remember what I said to you? Overriding to the interest of justice. So the said expert shall not have any conflict of interest with bank. Okay, very important. And mode of proof. You discuss a bit of mode of proof because I think this is satisfying. You can submit this satisfying. The expert evidence has satisfied the requirement of Section 60, whereby Dr. Ismail is giving his oral testimony in court lah, and then will subject to an oath, examination in chief, cross-examination, and re-examination. You can put forward one more section, Section 137. Okay. And so at the end of the day, what is your decision? What do you want? I mean, what can you come out with your clever and learned decision? Okay, based on this piece of evidence. So I rely on the factual circumstances that given by this question, and you can deviate from me. This is my personal opinion. Okay. So as a matter of fact, Bang had a heated argument with Chabo and lost control of the car, which result in the accident. I salim bulat-bulat from the first paragraph. The court has judiciously considered Dr. Ismail's evidence. However, the court is opined that such mental status were not negated by a psychiatric defect, as pleaded by the defense. The court leaned towards the belief that the defense of insanity was attributed to Banks after the tragic accident. Because I want to convict him, so I have to submit solely. Because anyhow, the discretion is with me, ma. I'm the presiding judge. I can choose to believe the Ismail or not. It's up to me. So you can submit whatever you want, lah. But make sure you are at the right direction. I mean, if you are at the right, don't suddenly the formulation of the drafting of your answer a little bit unsure there will be a ground for appeal lah. Okay, so therefore, Bank shall be convicted for the offense of reckless driving causing death. Okay, so at last of the paragraph, you can see the question here. Be very sharp, please. So you see, the death of his girlfriend caused depression in Bang, and now Bang has to go under this ECT. That is the brain. It's like shocking the brain. So is it have anything to do with our conviction or not? So I will put one sentence to conclude. Okay. For the purpose of mitigation after conviction, the court may take into account bank depression and his need for electroconvulsive therapy. The defense counsel should raise these facts during his submission. So at this moment of time, I don't think depression has anything to do with Section 41 RTA. This is totally out. Okay, but during mitigation time, like already convict, now want to reduce the sentence for me, isn't it? Now you can say lah, I am very sad. I need this treatment, all that. Oh, can, but later stage of this case. Okay, so this is my personal suggested answer lah. And last but not least, we come to one more, the civil case, because I want to show you the comparison. So Harold met Maggie on a dating website named Find Her in March 2017 and immediately embarked on a sexual relationship. So in January 2018, Maggie discovered from her gynecologist, OB, Dr. OB, that she had contracted herpes. Herpes means a form of sexually transmitted disease lah. So Maggie was very upset and coaxed Harold to marry her, claiming that he should do the right thing. After she discovered that she was pregnant, Maggie became more persistent with Harold to marry her. Harold agreed, and in May 2018, Harold and Maggie got married. In November 2018, their daughter Lillian was born. Harold's job kept him in the office for long hours and increasingly spent more time with his colleague, Chelsea. Maggie was upset with Harold's friendship with Chelsea and pressured him to end the relationship. This led to a vicious fight, resulting in Harold leaving the house in January 2023. Lillian witnessed the fight. Maggie then lodged a police report alleging that Harold had abused her. So in May 2023, Harold petitioned for divorce and Maggie cross-petitioned. Maggie wished to raise the issues of abuse, okay, keywords here, okay, abuse, adultery, and Harold had infected her with herpes. As evidence, Maggie wants to produce the following. So her daughter's testimony, okay, Dr. Obi's, the gynecologist's report on the issue of contracting herpes as sexually transmitted disease. But Obi is not called, and photograph that Maggie had taken of Harold and Chelsea having dinner on different occasions, holding hands and feeding each other with olives. So Harold, on the other hand, denied the abuse, adultery, and also denied everything lah. So Harold wished to raise that Lillian is not his daughter. So you are what? Okay, with reference to Evidence Act 1950 and reference case law, discuss the following. Okay, so pertaining to our question, I would like to discuss the admissibility of Dr. Obi's report. So automatically, by reading this question, it will project to your mind that this looks like an section 45 types of question. But is it really the case here? Okay. Okay, first and foremost, always have a mindset to decide is it a civil case or is it a criminal case? Because there is a distinction. Okay, so first and foremost, give a brief introduction. I would say this is a matrimonial divorce proceeding between Harold and Maggie, and straight away you submit. So Dr. Obi's report will be an expert opinion evidence because he's third party and he's a gynae, isn't it? Gynecologist. So under Section 45 Evidence Act, in which the said evidence has assisted the court in the area of science. Okay, because to go in Section 45, science is one keyword pertaining to the diagnosis of herpes. Do not just regurgitate the answer like a robot. Try to tally with the facts given in the question. So Dr. Obi should be required to state the grounds on how he arrived such conclusion. Section 51, Chandrasekaran. Okay. Nevertheless, Dr. Obi's absence, the mode of proof got problems, to give oral testimony according to Section 60 will render the said report to be caught by hearsay rule. You get me, Civil case tak ada just tender the report. Okay. It is tried law that the maker of the document shall come to the court to give evidence to prove the content of that particular document. Unless, unless there's a one exception, the document has been categorized in bundle A or bundle B by both parties. But in this case, Harold denies everything. So obviously it cannot be so lah. But to show your understanding, you better write something like that. Okay? So in furtherance, because like I say, specific case, specific uh specific statute, the the Latin maxim, the generalia specialibus non derogent. The specific act itself will prevail over any other act, inclusive of your evidence act, So you must fall back to the ground of divorce. This will be a bit challenge lah to students lah. I will really admit lah. Okay, even I myself during CLP time, I don't think I know all this. So section 53, 54 only actually provides because they cross petition, it's not a joint petition here. It's a single petition of divorce. There are only four grounds of divorce. Okay, so the grounds that applicable to Maggie's petition will be adultery and unreasonable behavior of Herod by way of abuse lah, because abuse will be one boleh diterima lah, kelakuan yang tak boleh diterima lah. And also adultery probably with Chelsea lah. That one also subject to very high burden of proof. Okay. So judging the fact that herpes infection, you see, you must be very sharp lah. Happens 2013 before the marriage. It is worth noting that this incident is not relevant at all under Section 5 Evidence Act. So on the basis of all the so-called force reasoning, dia tak hadir, ini relevant, so you will conclude at the end of the day, Dr. Obi's report could not be admitted in court. Section 136 Evidence Act. Okay, so opinion evidence in conclusion sometimes can relate to other area of law. This is what I'm trying to highlight to you.